Rescission is a powerful legal remedy in contract law that allows parties to cancel a contract and return to their pre-contractual positions. When a contract is rescinded, it's as if the agreement never existed in the first place. This legal concept provides important protections for individuals and businesses when contracts are formed under problematic circumstances. There are two primary types of rescission in contract law. The first is rescission in equity, also known as rescission ab initio, which rolls back the contract to the beginning, essentially voiding it from its inception. The second type is rescission de futuro, or rescission for the future, which is sometimes used to describe contract termination after a breach, though this usage is not technically precise. For a contract to be rescinded, there must be valid legal grounds. The most common grounds include misrepresentation, fraud, and undue influence. Misrepresentation can be innocent, negligent, or fraudulent. An innocent misrepresentation occurs when someone makes a false statement without intending to deceive. Negligent misrepresentation happens when someone carelessly makes a false statement. Fraudulent misrepresentation involves deliberately lying or omitting crucial information to induce someone to enter a contract. The process of rescission can occur in two ways. Voluntary rescission happens when both parties mutually agree to cancel the contract without court involvement. This typically occurs when neither party has performed their obligations or when both want to avoid litigation. Judicial rescission, on the other hand, requires court intervention when one party seeks to rescind the contract against the wishes of the other party. When a contract is rescinded, all parties must return any benefits received while the contract was in force. The goal is to restore everyone to their original positions before the contract was formed. No damages are awarded during rescission, and once complete, the parties cannot take future actions regarding the voided contract. Consumer protection laws provide special rescission rights in certain situations. The Truth in Lending Act of 1968 established a 3-day right of rescission for home equity lines of credit and mortgage refinancing. This cooling-off period allows consumers time to review complex loan terms before the contract becomes final. During this period, customers can cancel the contract without penalty, and the lender must return any fees and release claims to the property within 20 days. Similar rescission rights exist for other consumer transactions. Door-to-door sales typically come with a 3-day cancellation period under the Federal Trade Commission's cooling-off rule. Timeshare purchases often include rescission periods of 5 to 15 days, depending on state law. Many gym and health club contracts also have statutory rescission periods due to frequent consumer disputes. Despite having valid grounds, rescission may be denied under certain circumstances. If the injured party continues to act under the contract after discovering the issue, they may be deemed to have affirmed the contract, waiving their right to rescind. Unreasonable delay in asserting rescission rights can also lead courts to deny relief under the doctrine of laches. Courts may also refuse rescission if it's impossible to restore both parties to their original positions, or if it would unfairly affect innocent third parties. Rescission differs from other contract remedies like reformation and termination. While rescission voids the entire contract as if it never existed, reformation merely modifies the contract to reflect what the parties actually intended, typically correcting drafting errors. Termination ends the contract going forward due to breach, but doesn't necessarily void past obligations. Each remedy serves a distinct purpose in contract law. Rescission represents a fundamental aspect of contract law that helps maintain fairness and equity in contractual relationships. By understanding the grounds, processes, and limitations of rescission, parties can better protect their interests when entering into contracts and know their options when things go wrong.